This is next on the file.
That's what he said was next.
All right, this is docket 23266 FH, People in the State of Michigan versus Duran Maurice Wilson. Now for your appearances for the record.
Good morning, Your Honor. APA Bart Watson on behalf of the people of the state of Michigan.
Good morning, Your Honor. Melissa Patrick on behalf of Duran Maurice Wilson, who is appearing via Zoom.
All right, is he in the hearing room?
He's
All right, we
He's
need
on
him
Zoom,
to, we need someone to unmute him.
Mr. Wilson, can you have somebody unmute you?
Nobody in here, but.
Okay, we got you now, sir. All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you very much, sir. Sir, have you can put your hand down. Have you taken any medication yesterday or today?
yes, last night.
Okay, what is all that noise? All right. So you took medication last night?
Yes, I take seizure medication.
Okay.
What is going on?
What is that noise?
Somebody in the room with him or.
Is there someone in the room with you?
Around there.
I don't think so.
Okay,
It seems like just
There's some kind of echo going on.
echo, like a.
It's door in here. I hear by so I hear people talking behind me.
right. We can't have that because I can't hardly understand you and we need to make a record. It's not your fault, sir. It's whoever's talking in back of you. Yeah. I think they see you, they look back. All right, hopefully they stop talking. Thank you for that. So sir, you took some medication. Is it anything that would interfere with your ability to understand the court or your attorney?
No, just seizure medication.
Okay, are you doing okay today, sir?
Yeah, yes,
Okay, and have you had enough time to talk with your attorney?
yes.
All right, I understand there's going to be a plea today, is that correct?
Yes, ma'am.
And sir, are you a US citizen?
Yes.
And with what you're pleading to, were you on probation, parole, or bond conditions before another judge?
No.
Okay,
I was on parole.
you were on parole?
Yes.
Okay, so have they done anything to you in regard to this file, or do you understand that they may take action as a result of the plea?
Yes. Give me time.
Okay, very good. Ms. Patrick, you would agree with that? They've already handled it.
Yes, Your Honor.
All right, very good, thank you. On behalf of the people, what is the plea agreement?
Yes, Your Honor. The defendant will be pleading to an added count 5 and added count 6, both of attempted assault strangulation. He will be pleading no contest of both of those counts. After successful plea and sentencing, counts 1, 2, 3, and 4, and the habitual offender status will be dismissed. And then pursuant to the plea agreement, Your Honor, there is a killabrew to no upfront jail at the time of sentencing.
And is the reason for no contest civil liability?
No, the reason is, Mr. Wilson has had 2 strokes since he's been in prison. He has a very limited memory.
Okay. That certainly is good reason,
Yes, Your Honor.
along with civil liability given the circumstance, so.
Yes, Your Honor.
All right, very good. Is that full, fair, accurate, and complete?
It is, Your Honor.
Sir, did you understand the plea agreement? Is it full, fair, accurate, and complete?
Said me?
Yes.
Yes, ma'am.
Okay, thank you. And counsel, you're waiving reading counts 1, 2, 3, 4, and habitual third.
Yes, Your Honor.
As to reading of the felony information as to the added counts 5 and 6.
Yes, Your Honor, and there will be amended information that will be submitted.
Thank you.
People of the state of Michigan versus Duran Maurice Wilson. State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on November 20th of 2022, at 1564 North Aurelius Road, number 5, the defendant in added count 5 attempted assault with intent to do great bodily harm less than murder or by strangulation. The defendant did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or is prevented in the execution thereof, contrary to MCL 750.92. Assault with intent to do great bodily harm less than murder or by strangulation. Under MCL 750.84. Did make an assault upon Madison Marie Rodriguez by strangulation or suffocation, contrary to statute. As a this would normally be a maximum of 10 years and $5,000. However, as this is an attempt, this is a 5-year felony. Court shall order law enforcement to collect DNA identification profile sample. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. And then the added count 6, attempt assault to do great bodily, with intent to do great bodily harm less than murder or by strangulation. Did attempt to commit the following listed offense, and in the attempt did act towards the commission of the offense, but failed in the perpetration or is prevented in the execution thereof, contrary to MCL 750.92. That being assault with intent to do great bodily harm less than murder or by strangulation under MCL 750.84. That being, did make an assault upon Madison Marie Rodriguez by strangulation or suffocation, contrary to statute. This would typically be a maximum felony of 10 years. However, as this is an attempt, the maximum on this would be 5 years. The court shall order law enforcement to collect DNA identification profile sample. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. And it gets the dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes.
So you have counts 5 and 6, which are identical. Attempted assault with intent to do great bodily harm less than murder or by strangulation, punishable by 5 years or $2,500 and restitution to the victim for any personal or property damage or injury. Do you understand that?
Yes, ma'am.
And as to the advice of rights, you've gone over those rights with your attorney?
Yes, ma'am.
And you gave her permission to sign the advice of rights form on your behalf, is that correct?
Yes, ma'am.
Do you have any questions about your rights of your attorney or myself?
No, ma'am.
All right, thank you. Sir, as to count 5, attempted assault with intent to do great bodily harm less than murder or by strangulation, how do you plead?
Please, no contest.
And as to count 6, attempted assault with intent to do great bodily harm less than murder or by strangulation, how do you plead?
No contest.
Thank you, and that's based on your limited memory due to some medical issues with the stroke, and it sounds like you also have seizures, so the court finds that's good reason to accept no contest plea. But sir, do you understand that you are giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide defense, the ability to remain silent, not have that used against you. Additionally, if you had a bench trial or jury trial, you would be entitled to an automatic appeal if you weren't happy, but now it becomes the decision of the Court of Appeals if you want to appeal whether or not they accept your case. Do you understand all of that?
Yes, right.
And sir, if you were somehow forced or coerced into pleading, you need to tell me that now. Because if you come back later and say you shouldn't have pled, I don't have to accept that. So my question to you is, have you pled freely and voluntarily of your own free will?
Yes, ma'am.
And you did that after speaking with your attorney, is that correct?
Yes, ma'am.
And you're satisfied with the representation of your attorney, is that correct?
Yes, ma'am.
Now, other than the plea agreement, has anyone told you what I will do at sentencing?
No, nobody knows what to do.
All right, right, and that's true, I won't make up my mind until sentencing. So if I were to violate the agreement of no further upfront jail, then I would allow you to withdraw the plea, and this matter would again go to the pretrial stage. However, if you violate the law between now and sentencing, I don't have to honor that agreement, and I could sentence you to some more jail or prison time, and then you would not be able to withdraw your plea. Do you understand how that works?
Yes, ma'am.
All right, very good. Do I have a police report?
Permission to approach her?
Yes. Thank you. Thank you. By stipulation of counsel, defense counsel has handed me the Ingham County Sheriff's Office, police report, and the reporting officer was Jeremy Doherty, OERR, and the information contained reflects that Madison Rodriguez reported the father of her children, Duran Wilson, strangled her 2 times during the course of an argument over their children. She reported losing consciousness the first time, and she was seen at Sparrow Hospital due to the effects of the assault. This occurred on November 20th, 2022, between the hours of 7:45 hours and 8:15 hours. And it was in the township of Delhi, County of Indian State of Michigan, at a specific location known as 1564 North Aurelius Road, Unit 5. The officers responded, and after introducing themselves to Madison at the hospital, she told them she was really nervous and that Duran had a history of domestic violence with her, and she identified Duran Wilson as her assaulter. She said that they were in a verbal argument on the evening of November 19th, 2022, but the argument was not physical. And in the morning, that was in the evening, in the morning, in the early hours, she asked Duran if the two could speak about the argument the night before, and while talking to him, she indicates he became very angry and started to scream and yell at her, telling her she's not going to keep the kids away from, says her, but it must be him. Madison told Duran to leave. She said that is what set him off, and that he refused to leave, telling her he's going to remain wherever his kids are. And she continued to tell Duran to leave, and he continued to refuse. She then said he told her that he was going to beat her up. In an attempt to establish boundaries with Duran, Madison told him that she would not be assaulted again by him. She walked around him into the living room where he kept getting in her face. And Madison asked Duran to back up, at which time he grabbed her with both hands around her neck and throat. He choked her until she blacked out, and while being strangled, she tried to fight him off, but could not do it because he was too strong. She fell face up on the couch with Duran on top of her, and she scratched at Duran's hands, attempting anything she could do to get him to stop. And when she did that, she ripped his shirt and broke his necklace. And while being strangled, Madison remembered Duran telling her that she was not going to take away his kids from him. And she started begging Duran to please stop, and he did not. Madison told Duran, "I'm done. I'm done," as he continued to strangle her, but he would not stop. Madison reported she felt as though Duran strangled her to the moment where she was about to be done. And Madison said when she regained consciousness, she was upstairs, but did not remember how she got there. She shut the door to her bedroom, and he entered and continued arguing with her, and then was strangled a second time upstairs in the bedroom. She did not lose consciousness during the second assault because their daughter ran into the room and he stopped. I think that's enough factual basis for both counts 5 and 6. On behalf of the people, do you agree, or would you like additional information added?
The people are satisfied.
Counsel, do you also agree?
Yes, Your Honor.
Thank you. Our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
This court will have a court rule.
You have, Your Honor.
You have.
I find defendant's no contest plea to be appropriately made, and I also find that the no contest plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, 5 and 6 are entered. Counts 1, 2, 3, 4, and the habitual third in its entirety are dismissed.
This case brought us face to face with something courts deal with every day that most people never see. The moment a legal document stops being legal language and becomes something far more human. A mother, 2 children, a morning argument that turned into something no family should ever survive. What was read aloud in that courtroom was a police report. The judge read it without drama, without editorializing, without pause. But every word landed. She told him to stop. He didn't. She lost consciousness. She woke up somewhere she didn't remember going. And the only thing that stopped the second assault was 2 little girls running into the room. The defendant entered a no contest plea, not because the facts were disputed, but because 2 strokes had taken much of his memory. He appeared via video from a correctional facility where he has been held since 2022. He communicated with difficulty. He asked for the earliest sentencing date possible. There is no clean resolution in a case like this. There is a plea, there are counts on a docket, there is a sentencing date on a calendar. But the woman at the center of this, who begged him to stop, who survived, who reported it, she is the reason this case matters. She is the reason courtrooms exist. Sometimes justice is not dramatic. Sometimes it is a judge reading a report in a quiet courtroom and making sure every word is part of the permanent record. Because the record is how we say, this happened, and it mattered. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.